4. Issue of debentures. 4.1 Regulations governing issue of debentures. 4.1.1 Provisions for issue of debentures as per Companies Act, 2013. 4.1.2 Provisions for issue of debentures as per Companies Rule 2014. 4.1.3 Requirements as per SEBI. 4.2 Procedure for issue of debentures. 4.3 Debentures Trustees. Introduction. Companies prefer issuing debentures to raise funds as they can be repaid after a long period. A company can make public issue of debentures only if 1. The company or its promoters or its directors have not been prohibited from accessing the securities market by SEBI. 2. The company or its promoters or its directors have not been declared as a willful defaulter or has not defaulted in repaying any principal or interest on any debt securities for a period of more than 6 months. In this chapter, we will learn about the various regulations or provisions related to issue of debentures and the procedure for issuing debentures. 4.1 Regulations governing issue of debentures. A company issuing debentures has to comply with the provisions of the Companies Act, 2013, Companies Rules, 2014, RBI Guidelines and SEBI's various regulations. Depending upon the type of debenture, company has to fulfill the following provisions: Regulations, Act, Regulations, Guidelines. Provisions. 1. Companies Act, 2013, Section 71. Right pointing arrow contains provisions for issue of debentures. 2. Companies Rules 2014, Rule 18. Right pointing arrow contains provisions for issue of secured debentures. 3. SEBI Regulations, 2008. Right pointing arrow covers provisions for issue and listing of debentures which are not convertible, either into wholly or partly into equity shares. It is applicable if debentures are issued through public offer, private placement and for listed debentures. As per these provisions, company has to follow disclosure requirements as applicable to public issue of equity shares. Act, Regulations, Guidelines. Provisions. 4. SEBI Regulations, 2009. Right pointing arrow provisions for issue of debentures and listing of debentures that are convertible, either partially, fully or optionally into listed or unlisted equity shares. As per these provisions, a company has to follow the same disclosure norms as applicable to equity shares. 5. SEBI Regulations, 2015. Right pointing arrow provisions which a listed company issuing non-convertible debentures, perpetual debt instruments, etc. has to fulfill. The provisions relate to the various listing conditions which a company has to comply with. 6. RBI Guidelines. Right pointing arrow meant for banks which raise capital by issuing non-equity instruments. A company can issue secured as well as unsecured debentures. It can issue non-convertible debentures or debentures which can be converted fully or partly into equity shares. All debentures are redeemable, i.e. have to be repaid. Company can issue debentures to its members or make a public offer or offer it even through private placement. Company can also list its debentures on stock exchanges. The board of directors of a company have the authority to issue debentures. However, the board can use their borrowing powers only up to the limit permitted by the Articles of Association. If in case the board wants to increase its borrowing powers, they have to get the approval of shareholders in a general meeting through a special resolution. Provisions for the issue of debentures as per Companies Act, 2013, Companies, Share Capital and Debentures, Rules 2014. SEBI Regulation. 1. No voting rights. 2. Types of debentures. 3. Payment of interest and redemption. 4. Debenture certificate. 5. Create debenture redemption reserve. 6. Appoint debenture trustees. 1. Tenure of secured debentures. 2. Create charge on assets. 3. Appointment of debenture trustees. 4. Create debenture redemption reserve. 1. Minimum subscription. 2. Retention of oversubscription. 3. Underwriting. 4. Credit rating. SEBI Regulation. Companies Act, 2013, Companies, Share Capital and Debentures, Rules 2014. 7. Debenture trustees can approach NCLT 8. Impose restrictions 9. Punishment for contravention of provisions of the Companies Act. 4.1.1 Provisions for issues of debentures as per Companies Act, 2013. Following are some of the provisions of the Act which a company has to comply while issuing debentures. 1. No voting rights. A company cannot issue debentures with voting rights. Debenture holders are creditors of the company and so they do not have any voting rights except in matters affecting them. 2. Types of debentures. A company can issue secured or unsecured debentures and fully or partly convertible debentures or non-convertible debentures. To issue convertible debentures, a special resolution has to be passed in the general meeting. All debentures are redeemable in nature. 3. Payment of interest and redemption. A company shall redeem the debentures and pay interest as per the terms and conditions of their issue. 4. Debenture certificate. Company has to issue debenture certificate to the debenture holders within 6 months of allotment of debentures. 5. Create debenture redemption reserve. Company has to create a debenture redemption reserve account out of profits of the company available for payment of dividend. This money can be used only for redemption of debentures. As per Companies Amendment Rules 2019, MCA has removed debenture redemption reserve requirement for listed companies, NBFCs and housing finance companies. 6. Appoint of debenture trustees. If the company issues prospectus or invites more than 500 people, company has to appoint one or more debenture trustees. Debenture trustees protect the interest of the debenture holders. Company has to appoint trustees by entering into a contract with them called as debenture trust deed. Debenture trustees, they are institutions that protect the interest of debenture holders. 7. Debentures trustees can approach NCLT. Debenture trustees have to redress the grievances of debenture holders. If the company defaults in repaying the principal amount, on maturity or defaults in paying interest thereon, the debenture trustees can approach the National Company Law Tribunal for redressal. NCLT can direct a defaulting company to repay the principal amount or interest. Grievances, complaints redressal, remedy or compensation. 8. Impose restrictions. When the debenture trustee is of the opinion that the assets of the company are insufficient or likely to become insufficient to redeem the principal amount of debentures, it may approach the NCLT. NCLT can order a company to restrict incurring further liabilities so as to protect the interest of the debenture holders. 9. Punishment for contravention of provisions of the Companies Act. If the company fails to comply with any provisions of the Act, then the company and its officers shall be liable to pay fine or imprisonment or both as prescribed in the Act. 4.1.2 Provisions as per Companies Rules, 2014. If a company issues secured debentures, company must fulfill the following conditions. 1. Tenure of secured debentures. All secured debentures should be redeemed within 10 years from the date of its issue. Only certain companies like companies engaged in infrastructure projects, or companies permitted by the Ministry of Corporate Affairs, Central Government or RBI can issue debentures beyond a period of 10 years but not exceeding 30 years. 2. Create charge on assets. Company has to create a charge on the assets of the company or its subsidiary company or holding company. The value of charge should be adequate to cover the entire value of debentures issued and interest to be paid on it. If a government company issues secured debentures which has central or state government's guarantee, then it need not create any charge on its assets. 3. Appointment of debenture trustees. Before issuing prospectus or offer letter, the company has to appoint a debenture trustee. Company also has to execute a debenture trust deed either before issuing prospectus or offer letter or within 60 days from the allotment of debentures. The deed contains the terms and conditions agreed upon by the company and the trustees and clearly states the role of the debenture trustee. 4. Create debenture redemption reserve. Company has to create a debenture redemption reserve account out of the profits available for payment of debentures. Company has to maintain at least 25% of the value of its outstanding debentures in the debenture redemption reserve account. Company has to invest or deposit on or before the 30th of April each year, a sum not less than 15% of the amount of its debentures maturing during the year ending on the 31st of March of the next year. Money from this account is used for redemption of debentures. 4.1.3 Requirements as per SEBI for issue of debentures. 1. Minimum subscription. SEBI Regulation, 2008 Regulation 12 state the minimum subscription to be collected by a company. As per SEBI, the minimum subscription for public issue of debentures is 75% of base issue size, i.e. 100 crore rupees. If the minimum subscription is not received, the entire money received should be refunded within 12 days from the date of closure of the issue. 2. Retention of oversubscription. Company can retain oversubscription money up to maximum 100% of the base issue size or any lower unit is specified in the offer letter or letter of offer or prospectus. 3. Underwriting. Company may enter into an underwriting agreement with underwriters for its public issue of debentures. Appointment of underwriters must be mentioned in the offer letter or letter of offer or prospectus. 4. Credit rating. SEBI Regulations, 2018 states that companies should get credit rating for issuing debentures. As per SEBI, companies making a public issue a right issue of convertible debentures must obtain credit rating from one or more credit rating agencies. The rating should be mentioned in the offer letter or letter of offer or prospectus. Credit rating. Rating given to the debt securities by a credit rating agency which indicates the credit risk level. Credit rating agency. Agencies like CRISIL, CARE, etc. which rates the credit worthiness of a company issuing debentures, deposits and other debt securities. Additional information. CRISIL rating scale for long-term debt instruments including debentures. Rating meaning CRISIL a highest safety CRISIL big risk CRISIL a high safety query high risk CRISIL adequate safety CRISIL default CRISIL BBA moderate safety. 4.2 Procedure for issue of debentures. 1. Pass resolution in board meeting. 2. Hold extraordinary general meeting. 3. Filing with registrar of companies. 4. Obtain credit rating. 5. Enter into underwriting agreement. 6. Issue prospectus, offer letter, letter of offer. 7. Open separate bank account. 8. Receiving application money. 9. Hold board meeting. 10. Issue of debenture certificate. 11. Make entries in the register of debenture. Following is the procedure to be followed by a company issuing debentures. 1. Pass resolution in board meeting. In the board meeting, following resolution will have to be passed. Amount and type of debentures to be issued and the terms and conditions for issue. Approve prospectus or offer letter or letter of offer. Approve appointment of debenture trustees and get their written consent. Authorize board to create charge on assets of the company. Call extraordinary general meeting if the board's borrowing powers need to be increased. Authorizes board to open a separate bank account for receiving money from applicants. 2. Hold extraordinary general meeting. If the borrowing powers of the board is to be increased, EGM must be held to get the shareholders' approval through a special resolution. 3. Filing with registrar of companies. Secretary has to file the special resolution and copy of prospectus, offer letter, letter of offer with registrar of companies within 30 days of board meeting. 4. Obtain credit rating. Company gets its debentures rated by one or more credit rating agencies. The ratings must be mentioned in the prospectus, offer letter, letter of offer. 5. Enter into underwriting agreement. Company enters into an underwriting agreement for underwriting its debenture issue. 6. Issue prospectus, letter of offer, offer letter. Company issues prospectus if it is inviting the public to buy its debentures. Offer letter is issued if a company makes private placement and letter of offer for rights issue. 7. Open separate bank account. Company opens a separate bank account in a scheduled bank to receive the money from the applicants. 8. Receiving application money, subscribers will submit their application along with the required amount to the specified bank within the time period mentioned in the prospectus or letter of offer, offer letter. 9. Hold board meeting. After the issue closes, a board meeting is held to decide and approve allotment of debentures. Board also approves creation of charges on the company's assets. 10. Issue of debenture certificate. The allotment procedure has to be completed within 60 days from the receipt of application money. Company has to issue debenture certificate within 6 months of allotment of debentures. 11. Make entries in register of debenture holders. Secretary has to make entries in the register of debenture holders within 7 days after the board approval of allotment. However, if debentures are issued in demat form, company does not maintain the register of debenture holders. 4.3 Debenture trustees. A company which issues prospectuses or invites more than 500 persons to buy its debentures has to appoint one or more debenture trustees. Companies issuing secured debentures also must appoint debentures trustees. Debentures trustees are institutions which protect the interest of the debenture holders. The company creates a charge on its movable or immovable assets or assets of its subsidiary company or holding company. Charge is created in favor of the debenture trustees. The trustees become the custodian of the assets on which charge has been created. Debenture trustees is appointed before prospectus or letter of offer, offer letter is issued within 60 days after the allotment of debenture. The trustees must give a written consent to act as debenture trustees. The prospectus or letter of offer, offer letter must mention the names of debenture trustees. Debenture trust deed. Company enters into a contract with one or more debenture trustees. The terms and conditions of the agreement is written in the debenture trust deed. It is a legal instrument conveying the assets of a company to the trustees. The deed also defines the rights of debenture holders and the duties and powers of debenture trustees. Company has to execute the deed within 3 months of closure of the issue. Members as well as debenture holders can inspect the deed and also get a copy of it by paying a certain fee. Activity. Find out about the debenture trustee services offered by IDBI Trusteeship Service Limited. Find out 2 institutions offering debenture trustee services in India. Summary. Companies prefer issuing debentures as they can be repaid after a long time. Companies can issue secured or unsecured debentures, non-convertible debentures or convertible debentures, either fully or partially convertible or redeemable debentures. Debentures can be listed on stock exchanges. Company can issue debentures to its members, public or make private placement. Companies have to comply with the provisions as per the Companies Act, 2013, Companies, Share Capital and Debentures, Rules, 2014 and Regulations of SEBI. Company appoints one or more debenture trustees to protect the interest of debenture holders. Debenture trust deed contains the terms and conditions agreed between the company and debenture trustee. Deed is signed within 3 months of closure of the issue.